Hello, friends. I welcome you all to this 31st session of Law of Evidence. And today we are going to read about Section 66, Section 67, and 67A of Indian Evidence Act. Let us have a brief overview as to what all we are going to read in it. So, one is what are the circumstances in which notice to produce primary document is not required? So suppose there is a party A and opposite to it is a party B, and party A wants to give a secondary evidence. Then secondary evidence saying that the primary evidence is with B. Then in that case, before giving secondary evidence, he has to give a notice to B to produce the primary evidence, and if B fails to produce the primary evidence, then secondary evidence can be given by A. So, to cut it simply, that before giving secondary evidence, a notice has to be given to the person who is having the original evidence or primary document. Now, there are certain circumstances in which this notice is not required. What are those circumstances? That is what one of our point will be. And another is what are the various modes of proving handwriting or signature. So suppose if there is a document and it is said to be in handwriting of person A, then it has to be proved that this is the handwriting or signature of A. Then what are the modes of proving it? That also we will see. So let us start with section 66, which says that rules as to notice to produce. Secondary evidence of contents of a document referred to in section 65 clause A, that is which is in the possession of the opposite party and not in the possession of the party who wants to give the secondary evidence. So secondary evidence of contents of document shall not be given unless the party proposing to give secondary evidence has previously given to the party in whose possession or power the document is such notice to produce as is prescribed by law, or if there is no notice is prescribed by law, then such notice as the court considers reasonable. So as I told you earlier, that if this is a document, a secondary evidence which party A wants to give, claiming that the original, that is primary evidence, is with the party B, then before he can give secondary evidence, he has to give a notice to B, the person in whose possession the primary evidence is. And if then B denies or fails to produce primary evidence, only then A can give the secondary evidence as such. However, there are certain circumstances when this notice is not required. What are those circumstances? Provided that such notice shall not be required in order to render secondary evidence admissible if any of the following case the court thinks fit to dispense with. 1. When the document to be proved is itself a notice. Now, when this notice is itself to be produced, in that case, no further notice is required. Else, it will be a vicious circle, that is, again to prove this notice, give one notice. In order to prove this notice, give another notice. So, this will be never ending circle. Therefore, in order to produce the document, the notice itself, one need not give a further notice. Then, from the nature of case, the adverse party must know that he will be required to produce it. So, from nature of the case, the adverse party must know that he will be required to produce it. So, when it is in the knowledge of say party B that uh, the nature of that he will be required to give the original evidence, then in that case also notice need not be given. When it appears, third, it says that when it appears or is proved that the adverse party has obtained possession of the original by force or fraud. So, when say party B has obtained the possession of the original by force or by fraud, in that case also the notice need not be given. When the adverse party or his agent has original in court, so when the original is already present in the court, in that case also, as it is already present there, the notice need not be given. When the adverse party or his agent has admitted the loss of document, when B says that document is already lost, then in that case there is no use of giving notice because already it is submitted that the document is lost. When the person in possession of the document is out of reach or not subject to the process of court. So when if no notice can be given to B, if he is say a foreigner or an ambassador of foreign country or foreign sovereign, then it is out of the reach of the court or not subject to the process of court. In that case also section 66 is notice is not required to be given. Now, in order to remember it, I have made one simple formula or acronym you can say, and this is your Lanka far. So Lanka was far for Hanumanji, yet he went to Lanka and burned it up. This just to remember L, and we will not take these A which I have written in small, L and K F A R. So L stands for when the document is lost. So when the party B says the document is already lost, then notice need not be given. N stands for notice when the thing that is to be produced is the notice itself, then in that case also notice need not be given. K stands for knowledge when B already has the knowledge that he has to give produce this document, in that case also notice need not be given. F stands for force or fraud, as if in case the original document or P, that is primary evidence, is taken by B from A by force or fraud, then certainly sending notice would serve no purpose because already his malified intention is shown. A, when it is admitted that it is already present in the court in original, and R, when it is out of reach, when B is out of reach of the court. So in these cases, one need not give the notice as required under section 66. Now section 67 we will see proof of signature and handwriting of person alleged to have signed or written document produced. If a document is alleged to be signed or to have been written, wholly or in part by any person, the signature or handwriting of so much of document as is alleged to be in that person's handwriting must be proved to be in his handwriting. So if suppose this is a document and there is some handwriting and it is alleged that it is handwriting of A, and suppose this is a signature of A and it is said that whether this is signature of A or not, then we have to prove that this is handwriting of A and this is signature of A in order for the court to make it to take to make it admissible before the court. So to make it admissible in the court, we have to prove that this handwriting belongs to A, this signature belongs to A. This section never says or does not prescribes the manner in which it is to be um, proved. However, there is there are three important way in which it can be proved. and that you can remember from ACE. You have seen task ka patta jo, and the where ACE is there. So A stands for when a person who is acquainted with the handwriting, he can give as under provided under section 47, or by comparison this person's previous handwriting can be taken, and or he can be asked to write, and that can be compared in the court or by the court under section 73, or an expert evidence can be taken in this regard under section 45. Then section 67 says proof as to electronic signature. Except in case of secure electronic signature, if the electronic signature of any subscriber is alleged to have been affixed to an electronic record, the fact that such electronic signature is electronic signature of subscriber must be proved. So in case of electronic signature, it has also to be proved that this electronic signature belongs to that particular person. So we will just revise what all we have done, that in order to produce secondary evidence, the party has first to give notice to that party which has the primary evidence. But in 6 cases, this can be dispensed with if it is lost, if the document is to be proved is notice in itself, the person, the opposite party has knowledge of it, or the opposite party has obtained it by force or fraud, force and fraud, or if it is already admitted in the uh, present already in original in court, and or if it is out of reach of the process of the court. Then section 67 says that a handwriting or signature has to be proved. There are basically three methods. One is person who is acquainted, he can prove it, or it can be proved by comparison or by expert evidence. And then section 67 says proof as to electronic signature, that electronic signature has also to be proved except in case of secure electronic signature. Thank you.